says he expects to see more notes to the judge from the jury because there are so many elements to this case. Brett Tolman is here, a former federal prosecutor and a former U.S. attorney for Utah. I want to get to that in just a minute. But, Brett, back to what Jonathan was just reporting on there and what could happen here. And a sentencing having to wait till after it's appealed. Can you add to that? I feel like we're all being brought along here on all the many possibilities that could happen. But what could that look like?
Yeah, Sandra, it's there's so many different potential outcomes here. Let's assume then a guilty verdict. There could be an emergency appeal filed immediately with the Supreme Court of the United States to stay the imposition of sentencing and to address several different factors. I would think highest on the list would be the jury instructions. Then you would have what was allowed in as evidence. I think you'd also have the potential to immediately appeal the application of the law in this case, and the manipulation of the law could be something that the Supreme Court is interested in. We could not have that. The Supreme Court could say, I'm not going to grant a stay, and then Judge Merchan is going to be faced with the difficult decision on sentencing.
Yeah. Brett, I wanted to ask you this question on the instruction to the jury about unanimous on a guilty verdict, but not unanimous on the predicate crime. He said this: although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were. And there's three choices. So you could have a possible scenario where 4 jurors say he's guilty of this, and 8 jurors say, no, he's not guilty of that. 4 jurors say, well, he's guilty of this. And the other 8 jurors say, no, he's not guilty of that. And then another 4 jurors say, well, he's guilty on this. And the other 8 jurors say, no, he's not guilty on that. So in that scenario, at any one time, you've got 8 jurors saying, no, he's not guilty of that. So how do you convict on that basis?
Yeah, and John, there's a nuance here that's not really being discussed. The jury instruction that allows for that actually then takes us back to the Sixth Amendment and the ability of a defendant to actually know what they are being charged with. You cannot put on a defense if the jury is allowed to have multiple predicate crimes that it's going to review and reach a verdict on. So there's a combination here of both bad instruction, bad allegations and charging documents, and the due process that a defendant is entitled to. I would not be surprised if the Supreme Court says, even if we don't think there has to be a unanimous verdict on the predicate charge, we are troubled by the impact it has on the Fifth and Sixth Amendments of due process.
So it seems like you're making a prediction here on more questions from the jury, more notes, because of just so many specific instructions from this judge.
Yeah, and I think it's actually problematic that the judge is not willing to give the jury the instructions, the law. It's not unheard of. It's fairly typical for the jury to say, can we have a copy? The judge certifies it's accurate and submits it, and then they can reference the law themselves. Instead, this is a control tactic by the judge in order to maintain the narrative.
All right, Brett Tolman, we appreciate your input on all of this. Have a great time in the mountains.
Thanks, Brett.
Looks nice.
Thanks.